Class actions are an established form of litigation in Canada. Most class actions in Canada are litigated in the provincial courts of Ontario, Quebec, and British Columbia, but can be commenced in any province or territory. There are a number of strong and well-resourced firms engaged in identifying suitable claims to bring as class actions. Practically speaking, many class actions are developed by lawyers who then work to identify appropriate representative plaintiffs. There are also a number of litigation financing entities supporting class action litigation in Canada. Over the last several years, there has been a significant increase in the yearly number of class actions filed.
There is no category of claims that has been determined to be inappropriate for class action litigation in Canada. Securities, mass torts, product liability, and employment continue to be a frequent subject of class action litigation. Recent trends in Canada have seen an increase in privacy or data breach claims, secondary market securities class actions, consumer protection claims, and competition or antitrust litigation. Canadian courts have also seen an increase in class proceedings commenced against public authorities and government entities. Class action trends in Canada often follow litigation patterns in the United States, and many of the actions filed in Canada are copies of actions that have been or are being litigated in the U.S.
Class actions are not subject to any special limitation periods. The applicable limitation period will depend on the subject matter of the claim, as if it were an individual action. Most common law provinces in Canada have a general 2-year limitation period from the date the claim was discovered, and Quebec has a general 3-year limitation period. In most provinces, once a class proceeding has been issued, the limitation period, which would govern the claims of individual class members, is suspended until the certification motion is decided.
The method by which damages are calculated in a class action is generally no different from an individual claim. The main difference is that class action legislation in all Canadian jurisdictions permits the court to assess and award damages on an aggregate basis where appropriate. Aside from a cap on individual damages for pain and suffering as a result of personal injuries in the common law provinces, there are no caps on the damages that can be recovered in a class action in Canada. Punitive, aggravated, and moral damages in Quebec are commonly sought as part of class action proceedings in Canada. However, other than in Quebec, such awards in Canada are rare and tend to be modest, even when awarded.
A unique challenge of class action litigation in Canada is that the courts of each province or territory have the authority to independently certify a national class action. It is not unusual to have, at the same time, overlapping class proceedings in different Canadian jurisdictions. Canada does not have an equivalent to the multi-district litigation procedure in the United States to manage these cases together. Instead, the coordination of overlapping proceedings depends on the individual judges managing them. The test for certification or authorization, as it is called in Quebec, is less stringent in Canada than it is in the United States. Most notably, there is no requirement that the common issues predominate over those that may be individual to each proposed class member. A single common issue that will advance the proceeding may be sufficient. Canadian law does require that a class action be the preferable procedure for resolving the claim. However, this requirement has traditionally not been applied rigorously. BLG's Class Actions Group has extensive experience in defending cross-border class actions. As Canada's law firm, our reputation has been built around providing the best Canadian legal representation in collaboration with non-Canadian counsel to ensure a consistent strategy. BLG's cross-border experience includes cases raising both jurisdiction and choice of law issues. It is important to retain the right counsel from the outset, as these issues need to be considered at an early stage.
BLG Difference is a client-centered response, the best legal talent combined with the greatest understanding of our clients' priorities. For many potential defendants, class actions defense isn't primarily about the law. Class actions raise concerns about cost, diversion of management time, reputational risk, as well as both employee and public relations. We understand these concerns, and with our team of class action lawyers situated in jurisdictions across Canada, we have the specialized skill set and local know-how required to effectively identify and execute the client's strategic goals.